Court of Appeal in and for the 5th District in the state of Florida is now in session. The Honorable Adrian G. Sal, Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, well, good afternoon to each and all of you. It's a privilege for the 5th District Court of Appeal to be back in Jacksonville. The Marshal was kind enough to introduce me. I'm privileged to serve today on a panel. To my right is Judge Joseph Boatwright. To my left is Judge Jordan Pratt, of course, distinguished members of the court. And it's a privilege to be with them. We have one case set for oral argument this afternoon. It is the case of St. Clair versus, is it Marchia? The Dr. Marchia, my apologies. Dr. Marchia in Mayo Clinic of Jacksonville. As we get ready for oral arguments, just a couple of things, if I may. Of course, on the podium, you'll see the clock there. 20 minutes has been allotted for each side for purposes of their oral argument. Appellant's counsel is afforded the opportunity to reserve any portion, should counsel wish, for rebuttal. We customarily presume 5 minutes, but if you prefer a different time, please let me know, and we'll be happy to adjust the clock. You'll see the clock on your podium has a red light, yellow light, green light. You all are familiar with what that means, much like a traffic light. Of course, our esteemed Marshal Schultz will be operating the clock for the court this afternoon. We do have a number of people who are in the gallery in the courtroom this morning, or this afternoon. If I could ask everyone just to ensure your cell phones are turned off so as to not distract from the proceedings. If your cell phones are on vibrate, from years of experience in the trial court and the Fourth Circuit, you'll be surprised how loud that is on a wooden bench in the back. And so if you'll help us in that way, we would be grateful. With that, appellant's counsel, you're welcome to proceed. If you'll let me know how much time you all prefer to reserve for rebuttal, we'll proceed accordingly.
Your Honor, Aaron Sprague on behalf of the appellant Jim St. Clair. We will reserve 5 minutes for you.
All right, sir, you're welcome to proceed.
May it please the court.
Yes, sir.
I want to address the issues in the case in the order that they appear in our initial briefing, beginning with the issue of training placement. The plaintiff's second theory of liability in this case was that Dr. Marchia should have operated on September 20th to explore, find, and then repair the leak that was present in Mr. St. Clair. Relevant to that issue was the matter of abdominal drains, drain placement, and the change in drain color fluid. There were competing motions.
Counsel, you say it's relevant. I mean, I understand that the trial court had made several rulings about relevance and determined that it was not relevant. In my understanding of your appeal, what you're contending is that not that it was initially relevant, but rather that opposing counsel opened the door.
Correct, Your Honor. I was about to get to that, and I think that Your Honor is exactly right. Factually, I should say, drains, abdominal, and the color, changing drain color fluid related to that issue. But pre-trial, the court essentially ruled that neither side could use that fact to validate or invalidate the decision-making on September 20th.
And you don't contest that, right? I mean, the doctor's decision on September 20th, the reasonableness or not of that decision had nothing to do with the drain placement the day later, right?
Yes, but not until they made it relevant. Because at trial, that's exactly what they did. Had we had a trial where it was just factually put forward that drains were placed, time passed, drain color changed with no commentary, none of that would have changed the outcome or been relevant. But that's not what occurred at trial. And it began in opening statements. And I think that it's important to deal with the actual words that were spoken by defense counsel, because in the briefs, especially in the defense's brief, the appellee's brief, what we need is characterizations of what was said. But words matter. And I think that we need to look at exactly what was said, because their theory was this. There was no leak on the 20th. And then the wait and see approach taken by Dr. Murcia was therefore reasonable, and things happened and we had a surgery later. Now, in trial, they used the change in drain color fluid to support their theory on no leak present on the 20th and to validate the decision-making of the wait and see approach. And let's deal with what they actually said. Page 1882 of the transcript. And then, 3 days later, while he had the drain in, they were closely monitoring to see if a leak would develop. A leak did develop. Now I'm going to stop there, because he's talking about the 23rd. And he uses the phrase, if a leak would develop, implying clearly that no leak was present on the 20th, and they were monitoring on the 23rd to see if a leak would develop. And that's confirmed by the next phrase, a leak did develop. So he's clearly putting forth the theory that a leak had not developed until the 23rd. And what is the evidence of that they used to support that statement? The very next sentence. And the drain color turned brown, and they immediately went in and did the emergency surgery. This goes beyond mere factual recitation of what occurred. They are using the fact that the drain fluid color from the 20th to the 23rd was clear and then turned brown as evidence of the fact that they contend, which was there was no leak present until the 23rd. It's explicit. It's not a matter of inference. There's no need to resort to the vagaries of tone. That is what they said. Next. Page 1915. If there was a leak, it wasn't showing up on CT, so it would have had to have been very small at this time. And so even if there was a leak, and this is what Dr. Murcia is taking into account, if there was, it would have been very small. And so that's why he's monitoring it. And 40% of those leaks would be managed conservatively anyway. He then spends a paragraph talking about this conservative approach, and then he asks the following rhetorical question. And this was an incredibly difficult decision. I think that you will even hear from Dr. Mizell, their colorectal expert, that this was a very, very difficult decision to make for any doctor. And so, was that reasonable? So he introduces standard of care, negligence, and the concept of reasonableness. Next sentence is, ladies and gentlemen, we believe the evidence will show that this was not an unreasonable decision. And what evidence do they use to support their contention that the decision-making on the 20th was reasonable? And sure enough, 3 days later, the drain's in, drain fluid and the drain color turns brown, goes from kind of clear to brown, and now they know that there's a leak, and they immediately go in and do the full surgery on September 23rd. Explicitly and specifically linking the reasonableness of the decision-making on the 23rd, or on the 20th, to the change in drain color fluid. He has transgressed the court's pretrial order, and he has used the change in drain color, fluid color, to validate decision-making on September 20th.
As to what informed the decision-making on the 20th, there was a CT scan that was relied upon, I presume, by defendant's counsel or appellee's counsel.
Correct, and that was inconclusive.
And so their argument, as I understood it, at least correct me if you do it differently, is there was no leak, or if there was a leak, it was small and properly treated or reasonably treated by conservative care.
Correct, and then they go on and say, and as evidence of that, look at the change in drain fluid color.
Did at any point the plaintiff seek to utilize the improper placement of the drain as a violation or breach of the standard of care?
Your Honor, at pre-trial, there was a contention that that should be so used. However, that motion was denied. And at trial, after these arguments that I just read to you were made, plaintiff's counsel did not seek to introduce the drain placement as an additional theory of liability.
Right?
It was very, very clear at sidebar that we're not saying that they were improperly or negligently placed, merely that they were placed in such a way that they were not giving accurate diagnostic information. And that's the opinion testimony that these arguments opened the door to. If you're going to introduce the fact of a change in drain fluid color and then link that fact to reasonableness, then we should have the opportunity to rebut that by saying simply, the drains were not placed in a way to give accurate diagnostic information. And that's all we sought to do, but we were prevented from doing it.
So let me ask you this then. So as I understood the pretrial stipulation and the transcript from the trial, two theories of negligence were presented to the jury. The first, the manner in which the first surgery was performed, that being without diversion, correct?
I'm sorry, Your Honor, I'm not sure I understand your question.
Sure. So the first theory of why the doctor breached or how the doctor breached the duty of care was his decision to perform a one-stage bowel resection and primary anastomosis surgery without diversion. That was the first theory.
Correct, Your Honor.
All right. The second being then that when the symptoms, onset of symptoms 5 days post-surgery occurred, that he should have been taken directly to surgery again, and surgery performed to explore what the problem was and to remedy any physical difficulty.
That is correct, Your Honor.
So I guess what I'm wrestling with then is if the port was installed on September 21, the day after the decision was made for conservative care, how would it be prejudicial to your client to restrict testimony or limit testimony pertaining to the improper placement as alleged of the port if the port was not placed until after the decision that you contend was negligently made was made?
Yes, Your Honor, and to address that directly, had the defense not made the arguments they made, it would not have been error to restrict it in the manner that you described. But once they have linked reasonableness to a changing drain color fluid, then they have opened the door to that. And that's really what the opening the door concept entails, where something that wasn't relevant before or would have been inadmissible, for instance, in the Pelham case, it was Social Security benefits. Well, there's no way that comes in under normal circumstances.
Just to crystallize this, let's say that things had gone differently for you, and you had been able to ask the questions that you wanted to ask and elicit the information on the drain placement that you wanted to elicit. At closing argument, what would be the additional argument that you would have made at closing?
It would have been along these lines. You have heard from the defense, ladies and gentlemen of the jury, that the reasonableness of the decision that Dr. Murcia made on the 20th not to operate is evidenced by the fact that it took 3 days for the drain fluid to turn brown. Ladies and gentlemen of the jury, you heard from Dr. Mizell, who told you that in this case, those drains were not placed in a way to give accurate information. Therefore, this contention is erroneous.
Okay, so the opposing party's irrelevant contention as you framed it, right? Because it's irrelevant because the decision that you're really attacking on the standard of care issue occurred on September 20th, right? So you're responding to their argument that, the September 21st through 23rd events, are confirmatory for the September 20th. I mean, the pretrial stipulation had already conceded that that form of argument was improper, did not go to the standard of care. I understand you're making an opening of the door argument, but when a brass tacks, when the jury sits down to deliberate on whether or not there was a breach of the standard of care, I mean, would you concede that the argument that you just made is irrelevant to that question?
No, not under the facts and the procedures as they developed at trial. Again, this goes back to Judge South's question. Had things developed differently and only factual information had been given, then it would have been irrelevant. But as things developed, the defense made it relevant because they used those facts to buttress their opinion or their position on liability. And once they do that, then it becomes not only relevant, but highly important, because we then are not able to fully meet the defense's contentions in front of the jury. So, to address, I think, your question specifically, They did make arguments that under the pretrial stip were irrelevant. Once that happens, the relevance analysis changes because they have done that. They've interjected into the case, and so then that fact becomes relevant. That's the whole concept of opening the door. And we should have been allowed to meet that and go forward on kind of an even footing with the defense from an evidentiary standpoint, enabling us to fully address each one of the defense's contentions. If there are no other questions from the panel on this subject, I would like to move forward. On the second issue, the defense was allowed to erroneously present testimony that across 17 Mayo surgeons and an unknown number of Leahy clinic surgeons, the primary surgery percentage rate was 90% and only 10%.
Did your expert also testify to those diversion statistics?
The diversion statistics were mentioned by Dr. Mizell, but the context is different.
So why is it not appropriate for the defense to raise a similar issue?
Because, Judge Boatwright, I think you have to consider the context in which it came up. If we, in direct examination, had brought these statistics out in order to say, bolster our expert's opinion, then they would have been able to do the same thing. That's
Well,
not
on that line, I mean, didn't the plaintiff's counsel also ask questions about the statistics to kind of try to dial in the extent to which they were relevant, shed light specifically about whether or not the plaintiff's particular medical condition was similar to the third or so of cases in which Dr. Mizell performs a diversion? And so it seems like the plaintiff was making hay of the statistics as well, not just the defense.
I think that there are two answers to that question, Judge Brown. The first goes back to Judge Boatwright's question and deals with context. What we had is on cross-examinations, diversion statistics being brought up as an avenue to impeach our expert. In redirect, we addressed that briefly, but the decision to divert is primarily a clinical, not primarily, it's exclusive, a clinical decision based on the presentation of the patient having nothing to do with statistics at all. Just because the defense was able to cross-examine and impeach using statistics does not mean that they can then open their own door to then also bolster their own opinion based on...
Well, I mean, so there are different forms of argument that one can make. One could, make the argument that, these statistics show that 10% of the time, we divert, and therefore, right, full stop, we should not have diverted in this situation. One could also make the argument that these differences in the diversion rates show basically a credibility decision for the jury, right? We have different experts that have all testified that they divert at different rates, right? So we have a divergence as to what the standard of care should be, right? So, using the statistics, for that argument, I think you can see that that's proper, right? Your problem is with the first kind of argument. Is that correct?
If you are, I think I agree with you, Judge Pratt, if I understand you correctly, that the first avenue is improper. I would point out to the court that the appellee in their papers does not forward that theory as a justification for the statistics. They say it was part of Dr. Murcia's medical decision-making, which it clearly was not.
Well, don't they say in their brief that it wore on the credibility of the experts? Was that a contention not made below?
I think that it is true that they did use that to impeach Dr. Mizell. I think, though, that, again, the difference being, number one, Dr. Mizell is only relying on his own diversion statistics, not uncross-examinable statistics from other people. And two, the purpose for that was to impeach rather than to bolster. I see that I'm into my rebuttal time, well into my rebuttal time. As for the third issue, we're happy to stand on our papers unless the panel has more questions.
Okay, and I was going to advise, given the questions from the panel, I will extend an additional 1 minute to each side for arguments, so you'll end up with just about 3 minutes for rebuttal. Of course, you'll have the additional minute for your purposes. Thank you, Mr. Schmidt.
Please support Christy Russell on behalf of the athletes Mayo Clinic Jacksonville and Dr. Annette Machia. And with me here today is trial counsel Edward McCarthy and John Kaplan. It's undisputed that the plaintiff's medical condition is serious and complex and required decision-making on the part of Dr. Machia, for which there were no easy answers. And the trial in this case reflected that complexity. It was 13 days in length. There were 18 witnesses, 12 of whom were physicians, 17,000 pages of exhibits, most of which were medical records. The trial court was repeatedly called upon throughout the trial to make complex evidentiary rulings, considering the evidence in light of the issues that the parties stipulated would be tried, and particularly the standard of care issues. I think all parties in the court acknowledged that the jury was extremely diligent and engaged, and this was reflected in the record by the questions it was asking, making sure that it understood the medical evidence that was at issue. I don't think there's any dispute that there can only be a reversal of the jury's verdict if there is an abuse of discretion by the trial court, or if there is something in the record that constitutes fundamental error. And very simply, there is nothing that rises to that level in this case. With regard to the opening statement and the standard of care issues, the parties, as the court pointed out, specifically stipulated to the standard of care issues. And with regard to the second standard of care issue, it was tied to a particular date. Was Dr. Murcia's decision on September 20th of 2016 to take the conservative approach and not to reoperate on that day, was that reasonable? There had been a motion filed prior to trial, 2 months prior to trial, to amend the expert witness disclosure to add 5 new standard of care opinions. And the trial court said basically at this point, we're not going to amend the record to add these additional standard of care opinions.
Counsel, could you respond to your friend on the other side's, I think the citations were page 1882 and 1950 of the transcript where a couple of these statements were made. The briefing does sort of, categorize the statements rather than quote them. I'm wondering if you could address specifically, how we should interpret those statements of counsel if not relating to the standard of care. What is your view on, the line of argument that counsel was making, those portions of the transcript?
Certainly. So the first statement that I think was referenced is on page 1882 of the trial transcript portion. And that is a summary, essentially, of what occurred 3 days later. So trial counsel says, and then 3 days later, while he had the drain in, they were closely monitoring to see if a leak would develop. A leak did develop, and the drain color turned brown. That's consistent with what the trial court's pretrial ruling was. The trial court's pretrial ruling was...
Sure. Does that statement necessarily imply that there was no leak on September 20th, in your view? I believe that was your friend on the other side's contention, that there was necessarily implied in that statement, that there was no leak on the 20th. Do you read that statement the same way?
Yes. So, Your Honor, there are 2 issues that were being presented that go to liability. One is the standard of care issue, which is Dr. Murcia's decision on the 20th reasonable. The second really is the causation issue. So the defense's position on that was there was either no leak on the 20th or a small leak on the 20th. Plaintiff's position on that was that there was a leak on the 20th. So what's being stated here is that the evidence is going to demonstrate, from our perspective, that the leak did not develop until after the 20th. So that's the statement that's being made, and trial counsel saying, based on the facts of the record, that that's what's going to be shown. And that is consistent with what the trial court had said, and I'm just going to read just briefly from the motion in limine hearing. The court said, if you keep it factual, and you can talk about that they couldn't detect color of the fluid, maybe there would have been an earlier detection of the fluid based on the drain, but that's just going to be fact, and both sides are going to have to argue that.
Right,
So-
but whether there was a leak and the extent of any such leak on the 20th was a contested fact,
Yes,
right?
yes.
And it appears like you're making the argument there, or trial counsel is making the argument there, that, well, because the drain fluid was clear until, X date post the 20th, the leak did not develop, or at least was not so severe as to be detectable until the date that the fluid changed, right? So it looks like the argument is that the change in fluid color goes directly to when the leak developed.
As a causation question, Your Honor, because there would have been evidence presented by both sides as to when a leak developed. So that would be a recitation of the facts in connection with when the leak developed. The carve out from the trial court was very narrow. The trial court said you cannot criticize the location of the drain. That's what plaintiff's counsel could not do. And then neither side can use the drain fluid to validate or invalidate the reasonableness of a decision as to the standard of care issue. And the discussion was as to the standard of care issue. Now, there's also a causation question, which is essentially when did the leak develop? Because irrespective of the decision made on the 20th, there's still a question of, well, when did that cause any damage? And that would relate to when the leak developed. So the trial court was monitoring the evidence, the admission of the evidence in terms of both of those elements of liability.
So the drain was placed to tell whether or not there was a leak, correct? The drain was put in to show whether or not there was a leak?
The drain, I think, was put in for two reasons, Your Honor. I think one, potentially because there was an infection, so I think the drainage would have related to any potential issue with that. But then in addition to that, it would have been to monitor, yes. And
So why isn't it relevant where, if it was misplaced? That seems to be the basis of going back and doing surgery, correct? Of whether or not there was a leak. I mean, I don't understand why that's not relevant.
I'm sorry, could you repeat the question?
Yeah, why is the placement of where the drain was not relevant? I mean, if you're saying you're using the drain to tell whether or not there's a leak, why isn't the placement, if it was misplaced so you're not able to tell the leak, why is that not relevant?
No, the placement of the drain was not excluded. It was criticism of the location of the drain. There was no prohibition on evidence as to where the drain was located in connection with the anastomosis. And in fact, there was testimony by Dr. Mizell on that point. And I will say this, I mean, the appeal is limited to whether or not there was an improper statement made as to the standards of care. Not as to what evidence came in or didn't come in as to causation. But the question was whether or not either side could criticize the location of the drain, tying it back to the reasonableness of Dr. Muccia's decision. So that was the evidence that was very specifically excluded by the trial court.
How would you address Mr. Sprague's argument? How would not the three statements he read from transcript page 1882 and then 1915 on, how does that not open the door? In other words, we all know that to open the door to evidence previously excluded renders relevant that excluded evidence because it is now necessary to qualify, limit, or explain as testimony or evidence previously admitted, right? And so my question then becomes, if we're looking at the words of the transcripts as provided, does that not open the door then for the jury to receive additional testimony so that they can evaluate whether or not the change in fluid was validation of the decision on the 20th?
So the first point I would make about that, Your Honor, is, as I understood from the reply brief, the arguments being limited to the opening statement. And I think traditionally an opening statement is not evidence. So that is certainly one consideration. There was no objection made during the opening statement. There was never a proffer at any point as to what evidence should have been entered. There was no motion for a mistrial. after the opening statement. And I think very clearly in the reply brief, what was stated is that we're basing this on the opening statement. But to your point as to what was specifically said, so the first statement comes in as shown on page 1882 of the transcript. There's no objection there. The next statement that is the point of this appeal comes about 30 pages later in the transcript. And just going specifically, I'm going back to Judge Pratt's question here. So the question, I think, is this on page 1916, how do you interpret that if it's not validating the standard of care? And what is being stated there on page 1916 is a transitional point in the opening statement. So on pages 19, I believe it's roughly 1909 to 1915 of the transcript, what's being stated there is a discussion about the very difficult decision that Dr. Machia had to make on the 20th. And the summary there is, so he's closely monitoring from there to see if anything could develop. And the next statement is transitioning to, okay, here's what happened then from that point on after the 20th. 3 days later, the drain's in, and the drain color turns brown, and then that's what happens next. So it's taken in context, it certainly is a transition from discussing what happened on the 20th, and then transitioning into, okay, and here's factually what occurred from the 21st to the 23rd. So that's in terms of the statements there, because the trial court had said that certainly you can discuss things from a factual perspective. But I think it would be very helpful also to point out what the trial court did permit in terms of the admission of the evidence, because there certainly was evidence with respect to the placement of the drain in connection with both issues, both as to the standard of care and to the causation issue. So with respect to Dr. Meisel's testimony, which occurred on February 14th, February 14th, I just want to point out the testimony that actually is in the record. This is at pages 2241 to 2244 of the transcript record. Question: if drains are placed, what are the limitations on drains? And this is going to the inherent limitations on the drain as a monitoring tool. So the jury is hearing all of this because it goes to the inherent limitations in terms of what decision Dr. Machia is making on the 20th. The question: if drains are placed, what are the limitations on the drain? And then Dr. Meisel, the plaintiff's expert, goes into an explanation of that. And then he says, or if it's placed in an area that isn't close to your area of concern, that it won't really give you accurate information. And he goes on to explain what that limitation is and why it might be that it wouldn't give you accurate information. And there's another question. And so we have kind of an understanding of the anatomy, where would that area of concern be in the abdomen, and he explains that. And the witness even says, so the part of the connection was like over in this area, so kind of middle to upper abdomen would be where your anastomosis sits in the body. And question from the plaintiff: if there's a drain placed at the lower abdomen, what can limitations be? Answer: so if you place a drain in the lower abdomen, but the drain itself is far removed from the area in question. And so he goes on to talk about that. Then there's a follow-up question from plaintiff's counsel. Okay, I just want you to explain to the jury the significance of this finding from the drain on the 21st as to the presence of an anastomotic leak on the 20th. So now he's asking, okay, explain to us the significance of the finding from the drains on the 21st in terms of what was found when the drain was placed on the 21st to the presence of the leak on the 20th. So all this evidence is coming in through the plaintiff's expert. There is at no point during this discussion any request to proffer any additional evidence that was not in there.
But perhaps does the information, the questions and answers you just provided, does that lend support to Mr. Sprague's argument that we were deprived then of taking the next step in the questioning to say, applying what he had just testified to the drain in this particular case involving Mr. St. Clair? As I understand Mr. Sprague's argument, that's exactly where I would imagine, if I'm sitting in the trial at the time, he would be going, is that had he been allowed to ask further questions, he would have asked them right there then to apply it to this specific patient in this specific context. Am I misperceiving?
No, that may be where they were going, but I'm not sure there was a prohibition on that. The trial court said you can't criticize the placement of the drain because the expanded standard of care issue that was being presented was Dr. Murcia negligent in not knowing that where the drain was placed on the 21st wouldn't give accurate information, which again expanded the standard of care to the 21st.
Sure, and I understand, and maybe it's a fine line to draw, and maybe it's a fine line for a jury to draw, but as I understood Mr. Sprague's argument, he was not intending to argue placement of the drain as a breach of the standard of care, but rather a basis for the jury to question the reliability of the information as validation of the decision made on the 20th. Am I misperceiving his argument in that way?
No, I think that's his argument, Your Honor, but again, at this point, that evidence is, there was nothing that precluded him from asking the question of, for instance, given the location of the drain in relation to the location of the anastomosis, is it possible that a leak from the anastomosis was present on the 20th but would not have been seen until the 23rd? There is nothing that precluded that question. That would not have been criticizing the placement of the drain. That question could have been asked. And if there was any question as to whether or not that information should have been proffered, that's what should have happened. As a matter of fact, prior to this testimony from their expert witness on the 14th, plaintiff's counsel actually said, I may need to make a proffer, and the trial court said, well, I'll hear that. But no proffer was made. So certainly, if there was any indication here that there was some evidence that was not being admitted, certainly that should have been done.
Counsel, if we could move to the statistics real quick. What use did defense trial counsel make of these statistics of closing argument?
So the questions were first raised in connection with Dr. Mizell on cross-examination. And they really went directly to Dr. Mizell's articulation of the standard of care. Dr. Mizell's position was, well, he diverts in certain circumstances, and he diverts 1/3 of the time. And our position was that he was putting forth a standard of care that was much more aggressive in terms of when these procedures needed to be performed. So the questions that were being asked of Dr. Mizell were, okay, well, these are your statistics. This is what you do at your hospital. Yes. Okay, well, are you aware that at other facilities, this is different, that the rate is much lower? And so,
I understand how the dots can be connected in that way. I guess my question is, at closing argument, did trial counsel connect those dots with the jury in that way? What argument specifically was made before the jury based on that cross-examination evidence at closing argument?
The closing argument evidence would have been that Dr. Mizell's standard of care was not credible, that he was putting forth a standard of care that was not consistent with the standard of care of other physicians and other groups. Because his view of what would constitute a high-risk patient was different from Dr. Murcia's, from our expert witnesses. And so, therefore, it went directly to his credibility as to the standard of care and what would constitute a high-risk patient. So that's the argument that was being made to the jury.
Was it the same argument for the statistics that were brought out by Dr. Murcia and Dr. Marcello?
Yes, Marcello, the
Marcello.
defense counsel's defendant's expert. With respect to Dr. Murcia, there's an additional issue there. Dr. Murcia testified that physicians at Mayo coordinate on the standard of care in terms of what they're providing to their patients in this field. And so, and he also testified that he does consider that when he's making his decisions. So he's testifying on his own personal knowledge as to what decisions he makes as a physician, and testifying as to their efforts to coordinate and the consistency of what, that he took that into account to some degree. That was based on his personal knowledge.
Would you agree with the position that it would be an inappropriate argument to point only to the statistics as the reason why it was a reasonable decision for the doctor not to have diverted in this particular circumstance, without pointing at all to any of the particular factors of this plaintiff's presentation to the doctor? In other words, would you concede that relying only on that statistical evidence to extrapolate that the standard of care was met here, that would be an inappropriate form of argument, or at least inadequately supported by the evidence?
That was not the argument in the closing statement. There was a superabundance of evidence. The majority.
I understand that. I'm just saying hypothetically, if the only evidence had been, well, here are these statistics, the doctor didn't divert here, well, it's only appropriate 10% of the time, therefore the standard of care was met, you would concede that would be improper or insufficiently supported by the evidence to make that jump, right? That inference isn't the type of inference that would be permissible from statistical evidence. To say that these other doctors, do it only 10% of the time, therefore, we have these experts that agree with us that aren't here to testify, and therefore it was appropriate to not do it in this case, then that would be inappropriate.
I think it would certainly be inappropriate to rely on experts who are not there to testify. That would constitute bolstering. That's not that was not what was at issue here. In each of these instances, the physicians were testifying as to what occurred in their own practices and the rates of diversion in their own practices based on their own personal experience. And the vast majority of the closing statement was taken up with going through Dr. Mizell, a plaintiff's expert's medical testimony, comparing it to the medical records and deconstructing it, essentially is what defense counsel did. Vast majority of the closing statement was taken up with that. Very little spent on statistics. The point certainly was made that Dr. Mizell's position on standard of care and how often diversion procedures are performed was not credible based on the evidence that was presented. So for all of those reasons, we would request that the court the verdict of the judgment.
Thank you very much. Yes, sir.
I apologize, I'm going to move quickly considering the amount of time I have. The defense said that there was a stipulation as to the standard of care issues pre-trial. That is true. The issue is that the defense then transgressed that and went beyond in their opening statements and therefore opened the door. Judge Pratt, you very cogently asked the question, how are we to interpret these statements if not as relating to the standard of care? And that's exactly the point. The words speak for themselves. And let me address directly the assertion that these went to causation. They don't. Those statements don't have anything to say about a link between damages and negligence. The statement on 1882 is directly related to reasonableness in that it's not unreasonable to take a wait-and-see approach if there's no leak on the 20th. It's directly related to negligence, not causation. And as to the second statement on 1915, the words speak for themselves. They directly and specifically and explicitly link reasonableness to changing drain caloric fluid. There can be no credible argument that that relates to causation or anything other than the standard of care. As to the lack of a motion for mistrial or the need to proffer, that's addressed primarily in our papers, but that's an entire red herring, especially the need to proffer. What the defense ignored in the court below, and which they have now ignored in this arguments to this court, is that the trial court specifically held in its pretrial rulings that a proffer was not necessary, that the deposition testimony had been presented to him, and that it was preserved for appellate review. So the need to proffer this is an absolute red herring. Opening statements are not evidence. Again, they ignore the Ruchamora case. 307 Southern 3rd 95, cited in our papers. In that case, the door to evidence being presented to counter a defense theory was opened by statements in opening statements. And here we have statements in opening statements combined with factual testimony that absolutely opened the door to counter evidence. And they cannot get around the Ruchamora case. I would encourage the court to look at the sidebar, which started at page 1924 of the record, because there's been an assertion made that what we wanted to do was not specifically precluded by the court. That's patently false. We said several times during that sidebar that what we want to do is introduce the evidence that I outlined to the court in my argument in chief, and the court said, no, we're not going there. Factual only, cannot use to validate or invalidate. It was specifically precluded. And finally, just on the last issue, the court or the evidence on statistics was conduit for hearsay in that it drug in 17 Mayo doctors and an unknown number of Leahy doctors in contravention of Lynn v. Fosselman. That's what distinguishes it from Dr. Meisel's testimony. Thank you.
Thank you very much, Mr. Sprague. And let me say thank you to all counsel involved. The matter was exceedingly well presented, both in briefing and in argument today. We will stand for recess.
All rise.